Welcome again to Illuminated, a talk show that discusses solutions to real-world problems. I'm the state chair, Joseph Michael Carr, of the Independent Voters of Illinois Independent Precinct Organization, better known as IVI-IPO. I'm here tonight with our Public Relations Chair and co-host, Jim Garfield. I'm going to turn it over to Jim. Jim?
Hello, and welcome to Illuminated, a show from the Independent Voters of Illinois Independent Precinct Organization, or IVI-IPO. My name is Jim Garfield. I'm your host tonight, and we're joined by two wonderful guests. The topic tonight is going to be housing for people who have had sexual offenses in their past. Now, that might be a touchy subject, so if that's too much for you, you can turn it off right now, but I urge you to stick around, listen to what we have to say, and hopefully you can learn some more things. So let's turn to our guests right now. First, we're joined by Pam Rodriguez. Pam recently retired after 40 years at TASC, which is the Treatment Alternatives for Safe Communities, the last 12 of which she was the CEO. TASC provides services to people with substance use or mental health problems who are involved in the criminal, juvenile, or child welfare systems, and provides advocacy, reentry support, assessment, case management, and treatment services for thousands of people each year. Pam continues to work to expand opportunities for housing for people who have sex offense histories and serves on advisory boards for community organizations focused on reducing crime and violence, as well as national organizations focused on research specific to substance use disorders and recovery. Pam, thank you so much for being here.
Thank you.
All right. And our second guest today is Adele Nicholas. She is the Executive Director of Illinois Voices for Reform, a nonprofit organization that advocates for evidence-based laws. She's also a civil rights attorney whose practice focuses on laws and policies concerning people who have sex offense convictions in their history. She presently has 2 federal lawsuits pending on this topic, and I'm sure we'll get into those during the show. So Adele, thank you so much for being here.
Thanks for having me.
So I want to get a little background for our viewers who may not know. They may have heard of things like TASC, but they may not know any details about it. So what is TASC? Is it private? Is it part of the government? Can you explain some of that?
Sure. TASC is a private nonprofit organization. We provide services statewide in Illinois, as you indicated, in the criminal legal system, in the juvenile justice system, child welfare, and prisons and parole. Our goal is to, I say our goal, I am retired, but I still identify with us after 40 years. But our goal is to increase health and access to services in the community and keep people out of the systems that I mentioned. And so we have been for 45 years providing services to tens of thousands of people every year with a goal to increase public safety as well as increasing health and recovery in the community.
Now, what is the, I'll say, authority of TASC? What's the scope of it? As a private nonprofit, is there any kind of governmental authority for it and the work it does?
So there is a statute that we are based on, and that is the statute that allows within criminal court for people to seek treatment in lieu of incarceration. So that's the foundation of our work, and then all of the other work is built administratively on top of that. So there's administrative rule with the Department of Corrections that enables us to do reentry support, as well as in the child welfare system.
So would you find, for example, someone who's charged with a drug offense, possession or use of cocaine, rather than going to prison for their conviction, they instead go into a TASC program?
So TASC is a independent case management agency, and so we would assess that person for appropriateness for treatment in the community, and then make a recommendation for them to get services at one of any number of providers of substance use treatment, mental health services, et cetera. And so we work across the state with hundreds of treatment providers, housing providers, employment providers, et cetera. Anything that's necessary really to support recovery, reduce recidivism, and protect public safety.
Okay. Would task release for a conviction, would that be almost like a parole where you go through task instead of incarceration if you don't complete some kind of recovery program, then you would serve your prison time?
It compares more to probation. It's technically a probation sentence. And for listeners who don't know the difference, that means that you're supervised at the county level as opposed to the state level by parole authorities. It's possible if you reoffend that you could end up in the Department of Corrections as a result of that. The court has come to understand over the last 45 years that relapse is a part of the process, and so they have developed a broader understanding about giving people additional chances to succeed in treatment, reunify with families, et cetera, rather than immediately yanking people off the street and sending them to the Department of Corrections. So I think today we're in a better place in that regard. There are drug courts that do that, there's mental health courts that do that, and then other felony courts that enable people to go to treatment instead of the Department of Corrections.
Okay. Now, one thing I wanted to ask about is the phrase reentry support. Mm-hmm. I assume reentry is into the society, into community. Mm-hmm. What kind of support are we talking about here?
So about 30 years ago, we started working in the Department of Corrections to help people reenter communities. And so people who had participated in treatment programs in the Department of Corrections, and there are a few, would work with us on a pre-release basis to make a plan that's in partnership with parole for safe reentry. And in that, we would help arrange continuing treatment services if necessary, help arrange housing as appropriate, link people once they're out to employment services and support, et cetera. And so whatever folks who had participated, who had a substance use problem before going into prison, and then participated in treatment in prison, they would avail themselves of task services to support their reentry upon return to the community.
Okay. I want to turn now to Illinois Voices for Reform, which is your organization. You said it works for, let's see, evidence-based laws. What does that mean? What kind of work do you do?
Yeah, so Illinois Voices for Reform has, I'd say, 3 missions. One is to support advocacy for legislative change in Illinois. Illinois has some of the most restrictive sex offense laws and policies in the country, some of the most harsh and some of the most irrational laws in the nation. And so we work to support efforts to reform those laws where possible. We also support litigation efforts to challenge the constitutionality of those laws and policies where appropriate, and that's really how I got into this role of volunteering for Illinois Voices for Reform. Was my background as a civil rights lawyer. And then we also try to provide support to our, we don't really have members, but we have supporters, people who are affected by these laws. So it could be people who are subject to these laws and restrictions, or their families and their loved ones who also feel the effects of being subject to these restrictions, which often last for a lifetime after someone has a conviction.
Now, I do want to jump into, you mentioned sex offenses, and we're talking today about sex offenders who have been convicted and are now being released. We're all on the same page with that. What kind of restrictions are there on someone who has this conviction on their housing ability?
So in Illinois, there is a set of overlapping statutory, regulatory, and policy restrictions that people who have a sex offense conviction in their past are subject to. So to begin with, there is a criminal statute that imposes 500-foot banishment zones around all schools, playgrounds, daycares, and anywhere else that provide services to minors. Those restrictions apply for life. So that is long after someone is done with the sentence that was imposed by the criminal court, finished with any period of supervision, and even done with their period of registration that may have been imposed, they'll still be subject to those 500-foot restrictions forever. Then there are a lot of restrictions imposed by the Illinois Department of Corrections as a matter of policy on where people can live. And some of these are changing because of the litigation we've been involved with and some of the court decisions that have come down. But for a long time, they would impose restrictions on things like living at an address where there was internet access. Anyone with a sex offense in their background was not permitted to live in any home that had Wi-Fi or Wi-Fi capable devices, game systems. Even if someone had a smartphone in the residence that they weren't willing to give up, that could be a reason for denying the household. The presence of children's toys or items could be a basis for denying a host site that someone sought to live at.
And we're talking, are these all post-release, or are these, as a release during the time of incarceration, kind of a?
So Illinois doesn't have traditional parole, except for people who were sentenced before 1978. So anybody who's subject to these restrictions is on something called mandatory supervised release, which in a lot of ways looks like parole because the person has done a sentence of incarceration in the Department of Corrections, but is still under the supervision of a parole agent employed by the Department of Corrections. The difference under Illinois law is that mandatory supervised release isn't early release from an unexpired prison sentence. So it is a separate sentence of community supervision that only commences after you've completed the period of incarceration you were sentenced to. So we don't have indeterminate sentences that could be ended early with parole.
Okay, and so these policy restrictions are all for post-release. Someone who's been incarcerated, their sentence was 3 years, they've served it, they're now on mandatory supervised release for another 3 years. We're talking about that time after the sentence.
Yes, exactly. So the Department of Corrections, there is a state statute that says while a person is on mandatory supervised release, they must live at a, quote, department-approved location. And the Department of Corrections has a great deal of discretion to approve or not approve housing. And so we see all kinds of reasons being given for people's housing to not be approved. And the reason this has such a great impact is that people who have a sex offense conviction in their past won't be released from the Department of Corrections unless and until they can identify housing that meets all the statutory requirements and any requirements imposed by department policy. So at all times in Illinois, we have a lot of people who are stuck in the Department of Corrections past the period to which they were sentenced because they can't identify housing that complies with all of these laws.
So they would have to find somewhere that is not within 500 feet of anywhere that deals with children, and a place that doesn't have Wi-Fi, or anyone who lives there who has Wi-Fi or a smartphone or children's toys, so that no other, even family member children. They have to comply with all of those things for how long?
So all of those policies apply for the period of time that someone is on mandatory supervised release. And so that's set by statute. It depends on the conviction. For most people with sex offense convictions, the period is an indeterminate amount of supervised release of 3 years to natural life. And that has great interaction with the housing restrictions because under Illinois law, that period of supervision doesn't start to run until you actually get out. So we have clients who may have been sentenced to serve a year in prison, for example, to be followed by an indeterminate amount of supervised release of 3 years to life. And some of those people remained in prison after 10 or 11 years, even if they were only sentenced to 1 or 2 years in prison, simply because they can't find housing that complies with all of the rules that the department will approve.
Now, is that, well, I'll ask it this way, how would they look for housing while still incarcerated? How is that process done? I mean, would you go through something like TASK to find housing in that kind of a case?
Well, the truth is it's almost impossible. If you don't have someone on the outside helping you, it is impossible. And for a very long time, the Department of Corrections has taken the viewpoint that under Illinois law, they have no obligation to help people with identifying housing. So if someone didn't have someone on the outside helping them, they would just sign a slip that said, we couldn't find anywhere for you to live, therefore you're in violation of your supervised release and you have to stay in prison. So the truth is that without someone who loves you on the outside, family or friend, working very hard to find housing for you, it's impossible. And it's often impossible even with family working extremely hard on your behalf to help you pay for housing and give you a place to live and all of those things. I have clients who have submitted 12 or 15 different host sites, had their families pay for security deposits and first month rent on apartments 6 or 7 or 8 different times, had every member of their extended family offer to take them in, only for every one of those locations to be rejected because of the Illinois laws and policies. And so this really oftentimes results in people just getting stuck in prison indefinitely because it's so difficult, if not impossible, to comply with all those laws.
Now, in terms of the various statutory regulations, 500 feet from schools, anywhere that there's children, does it matter whether or not the offense that they were convicted of, does it matter whether the offense for which they were convicted had anything to do with children, or is it just any sex offense at all?
So this has changed a little bit over the past few years. So the statutory restriction only applies to people who were convicted of an offense that involved a minor, someone under 18 years old. And that would include people who have a conviction for looking at illegal images, so not a contact offense, but downloading something that is legally prohibited. But for a very long time, the Department of Corrections was applying those 500-foot restrictions to anyone with any type of sex offense, even though it was not required by law. As a result of a permanent injunction we had entered in one of our cases, they agreed to only apply that restriction as required by statute, which is to people who have an offense involving someone under 18.
And that's one of the class action suits that you've been involved in with your organization, is trying to make sure that that policy has to comply with the actual wording of the statute rather than department policy. Is that fair to say?
Well, we have 2 class action lawsuits, and the first one is called Murphy versus Raoul. That one was brought on behalf of everyone who has this 3 years to natural life sentence of mandatory supervised release and remains in the Department of Corrections past the completion of their criminal sentence because they can't find an approved place to live. And so the court found in that case that it was a violation of people's constitutional rights under the Equal Protection Clause and the Eighth Amendment to keep them in prison simply because they can't afford to comply with all of these regulations. But that decision was entered a few years ago now, and finding the solution is an ongoing process. So that case is still under federal supervision, and we're still working hard to try to change the laws and the policies that will enable people to actually get out of prison.
So is that law, for the folks who were involved in that case and who fit that class, are they now able to find housing that complies with the statute but not necessarily the IDOC policy since that ruling came down? Or are we kind of in a gray area where they're still incarcerated and maybe they'll get out at some point?
I guess I'd say it takes a long time to turn a ship is the cliche for this, and I think that some things within the Department of Corrections are changing in terms of how they do host site investigations and what they look at in terms of approving host sites. Other things haven't changed, and nothing has changed about the statutes that folks are subject to. So it's very hard, even if the Department of Corrections didn't impose any additional restrictions on where people could live, it's very hard to find something that complies with all of the 500-foot restrictions, especially in a dense urban area like Chicago, because it's not just a daycare that has a sign out front saying it's a daycare, it's home daycares too. So if any person on any regular city block in residential housing obtains a license from the Department of Children and Family Services to take care of even one child that's not related to them in their home, that will suddenly create a new 500-foot banishment zone in which no one with one of these cases in their past can ever live.
Which I assume during COVID times when an awful lot of home child health care was expanding, that this became an even larger problem.
Well, there's a lot of problems with it. One is that somebody can take out a license anywhere, right? So a place that looks like it's compliant with all the laws can very suddenly become non-compliant if someone gets a license to operate a home daycare. Illinois law does not grandfather in existing residences, meaning that someone who's been stuck in the Department of Corrections for many years after completing their sentence could finally find a place that complies with all of these rules, finally get out of prison, and then a day later, a neighbor could obtain a license to take care of one child in their home, and you have to move or go back to prison because even though you did nothing wrong and you had no idea someone was going to open a daycare near you, the law prohibits you from living there.
Now, in terms of finding housing for folks who are in a situation like this, does TASC have any kind of a role in that? Can they help find housing for folks who find themselves, hey, I don't have a family member who's trying to get housing, I don't have close friends. Can they turn to TASC as an alternative?
So right now, we're not doing that work. During COVID, when the department was releasing some additional folks specific to accelerated or good conduct credits and things like that, we thought we would be trying to access housing for people who had sex offense convictions, but we were only, the department was only giving us the names of people who already had approved host sites. So the way we get involved now is once someone is out and an approved site goes bad, like Adele was saying, where you move in and someone opens up a daycare or just applies for the license next door, and you have to move out. Then that person would be our client, and we would be helping them try to find a place. Unfortunately, a lot of those folks don't find places, and there are not apartments or landlords or places to live that meet the 500-foot requirement, and so they end up homeless.
Is it more common for them to end up homeless or to end up back in the Department of Corrections for violation of the statute?
Both things are possible, and I don't know, maybe you know which one is more likely.
Well, if you're on supervised release, you cannot be homeless. So if you are too poor to afford housing, they imprison you. If someone loses housing that they had, they cannot be homeless while on supervised release. They're going back to prison. After the period of supervised release,
You're just homeless.
yeah. And people are often pushed into homelessness long term because of these laws.
Now, we've been talking about finding a place to live, and it sounds like we're talking about rentals. If you're someone, however, who owns a home and you have this offense, could you be forced to sell your home, or you're allowed to keep owning it, but you're not allowed to live there? How does that work?
That happens all the time. People who are subject to these laws do everything right. They finally find a place that complies with this law, with all of these laws, and they make a home there and they stabilize their lives, and they may be doing well. It may be decades after their conviction. And if someone opens a prohibited use within 500 feet of you, you have to move out, even if it's a home you own. And it becoming an illegal place to live is not your fault at all. You didn't do anything wrong. You didn't commit an offense. You didn't try to commit an offense. Just someone opened something near you.
Now, this sounds like a very legal, technical question, but does that at all implicate the takings clause? You're allowed to own your home, but you're not allowed to live there. They've essentially made it worthless. Does that implicate any kind of constitutional rights like that?
Well, if you ask me, it does. If you ask the Seventh Circuit Court of Appeals, they don't think so.
Understood. Okay. So there is a conflict of opinion there, but there has been court rulings saying that that's okay.
Yes, we sued on that and many other bases on behalf of someone who was being kicked out of a home that they owned, had owned for decades, had lived in his entire life, and was told he had to move out because something prohibited had opened near him without his knowledge. And Unfortunately, all of those claims were rejected by the courts for reasons that I mean, I guess if I was going to boil it down to one reason, what I would say is that the courts want the legislature to do something about this. They think that it's really their job to pass wise laws. And so the comment that the courts made about this challenge we brought is that we're not here to comment on the wisdom or the effectiveness of these laws, but we are going to presume they're constitutional. So really, it's in the hands of lawmakers to do better and to pass laws that make sense, which we do not have right now.
How would, if you either own or even rent, you have a lease, someone moves in or someone opens a prohibited activity so you can no longer live there, how does that affect your lease terms? Are you legally required to move? Are you allowed to break your lease therefore, or do you still owe all the money? How does it affect a mortgage?
Yeah, those are extremely serious questions that I don't think our lawmakers have taken the time to grapple with. They passed a lot of laws that had a little bit of surface appeal when they passed them. And it gave them kind of a gimmicky way to say we care about safety. But truth is, these laws have been studied and they've been completely discredited as any kind of public safety measure. They do not reduce crime. They do not improve public safety. But we keep them on the books for reasons I don't understand. But our lawmakers have not been willing to change them. And all of these unintended consequences have been going on for a really long time, including the things you identified, people being on the hook for a mortgage for a house they can no longer live in, people being separated from their children, people having to uproot their children in the middle of a school year and move them to a different school because their house has suddenly become an illegal place to live.
This is a fascinating topic, but I'm looking forward to continue the conversation with you both. Thank you so much for joining us on Illuminated from the IVI IPO. Come back next time. We're going to keep having this wonderful conversation, learn some more about this topic.
Thank you again for watching Illuminated with IVI IPO. You've watched Jimmy Garfield and Joseph Michael Carr. If you're interested in becoming a member of IVI IPO, visit www.iviipo.org. If you want to renew your membership, you can follow that website link and renew your membership as well. Thank you again. Take care.